Claire Curran.
Yeah. Mr. Chair, every time in this Parliament, in this House, that there is a personal vote, a conscience vote, it is really incumbent on every member in this chamber, every member of Parliament, to really examine their consciences, because otherwise, why do we have conscience votes? And we are trifling with that as being a mechanism to make law. So, in my view, that is not happening with regard to this bill that is passing through the House, and that on the other side of the House, the consciences, the individual consciences of MPs are not being engaged in this bill. What my colleague Ian Lees-Galloway has just described, and other members, Mojo Mathers being one of them tonight in this House, is not so much about an issue to do with religion, but it's about an issue to do with culture and what Kiwi culture is and how we express that and how we value it and treasure it and make sure that it is valued, and that each of us as parliamentarians value it. What is happening with this piece of legislation is that it's being devalued and trivialised, and I think that is a serious matter. And I would hope that any of the national MPs listening to this debate tonight will reflect upon that and think that next time there is a conscience vote, that they really should insist on being able to exercise their consciences. Mr. Chair, I want to address my remarks to all of the clauses in this bill relating to local policy, the replacement of a bylaw and replacing that with a local policy mechanism, and to highlight why that is so flawed and how it's created a catch-22 situation for local government, and is fundamentally one of the reasons why I'm opposing this bill, because I think it's bad law, really bad law, and that there were other ways, if the government did want to bring this law forward, that they could have done it in a way that applied to the whole country, rather than requiring local government to use a mechanism that ultimately is not going to result in true consultation for local communities, and if it does, is going to cost the amount of money which they opposed en masse in the first place. So I want to refer to some advice that was given to the committee by the Ministry during the tortured process of this bill through the Select Committee on which I sit. And the committee was asked about the ability to judicially review whether a judicial review applied equally to both a local policy and a bylaw mechanism process. And the committee's advice was, from a constitutional perspective, the use of local policies to allow shop trading would be the same as using bylaws, provided the empowering provision was the same, the consultation process was the same, and the ability to review remains. Well, I want to just refer to two submissions, Mr. Chair, one from the Wellington City Council, which said that the Wellington City Council believes a consistent nationwide approach would be preferable to the proposed approach, and this was the bylaw, as it would ensure greater consistency and clarity for the public. It said the nationwide approach removes the need to know where the invisible boundaries lie between territorial authorities. This would be an issue not only for residents of a particular area, but also the many people travelling over holiday weekends, etc., etc. They say there are other instances where differences in approach between territorial authorities have been criticised for the inconsistency created and uncertainty caused. A nationwide approach would avoid this. I also want to refer to the Christchurch City Council, which gave an extensive submission which said that that it considered that the issue of Easter Sunday trading was a matter that should be decided at a national level. A clear decision is needed that would apply through the whole country. That the council submits that the bill would not reduce red tape. It would reinforce the loopy rule problems that were proposed by Paula Bennett, so that's a contradiction, that it was going to cost a lot of money, Mr Chair. Mr Chair.
Clear, Karen.
Thank you. It was a very long bell ring, Mr Chair. That the arguments used by these city councils, including the Auckland City Council and other city councils, was that it was going to that the imposition of a bylaw, of using a bylaw mechanism, was going to ultimately result in huge amounts of money being spent. In fact, they gave a submission to the committee on how much that was going to be, and the amounts ranged between 40 and 80,000 on per territorial authority as a standard. Some of them said it was going to be more, and then the committee came back and there was advice that came back to the committee and said, oh well, we won't use the bylaw mechanism. We'll use a local policy mechanism, which was going to somehow reduce the amount of cost to the local authorities, the 67 local authorities across the country. But I want to go back to that advice which was given about the constitutional issues, and that was that they, in order to remove any constitutional issues as opposed to using a local policy mechanism versus a bylaw, then they would have to do the same amount of consultation, and there would still be the same ability for a judicial review to occur. So ultimately, local authorities are left in the same position, that if they are going to apply that mechanism of a local policy, then they are open to the same risks which they opposed en masse in the first place. So ultimately, what this bill does is using another mechanism that appears to be less onerous on local authorities, but ultimately, unless they use it in the same way, then they're acting unconstitutionally. And that is the catch-22 situation of this bill. That is why it is fundamentally flawed. It is a bad piece of legislation. It's a piece of legislation that has been imposed on the House because of a policy decision that's been made by the National Party, requiring all its members to vote on a conscience issue, using a flawed mechanism that local authorities do not want, and ultimately being anti-Kiwi culture, and taking away something sacred. For some it's for religious reasons, for some it's for cultural reasons, which is the ability to spend more time with your families. So if they were going to do it sensibly, they would have imposed it as a national requirement across the country, where local authorities didn't have to make the decisions themselves using a flawed mechanism. So, Mr Chair, ultimately this is a very, very poor piece of legislation. It's shambolic. The Minister is having to introduce a major SOP on the committee on the floor, the committee floor of the House, to enable it to go ahead. Most city councils don't want it in the form that it was and that it is, and ultimately it is anti-Kiwi and anti-Kiwi culture.
Order. Before I invite Mr Hudson to take the call, I just want to clarify the leave that was taken previously by the House. I think it was probably not put quite as clearly as it should have been, but just to make it clear, I will seek leave again so that clauses 1 to 3, whether they stand part, are put as one question. which I think was the intention that everyone agreed to informally, but might not quite have been put to the House. Is there any objection to that? There appears to be none. Brett Hudson.
Thank you, Mr. Chair. It's wonderful to be able to speak